introduce the board here. To my left is Dave Zemnorowski. I'm Ned Simmons, Chair of the Board. To my right is Pat Lawson. We have one new matter on the agenda this evening, an administrative appeal of a building permit on the Tote Road, 23 the Tote Road. We'll also be considering the minutes of our July 9th meeting of this year. I'll quickly go through the procedure here. We do have a quorum. Dave Zemnorowski is an associate member. Since two of our regular members are out this evening, I'll appoint him as a full voting member for this meeting. In general, we try to keep this relatively informal and not too much rigmarole, but in general, the applicant will have an opportunity to present their case first. Anybody who wishes to speak should step to the microphone and identify yourselves in order to help the recording secretary keep track of who's speaking. It would be helpful if you sign in on the sign-in sheet near the door. Any questions and comments you make should be made through the chair. The applicant will be given an opportunity to present their case. Any interested parties will also have an opportunity to speak, including the CEO, abutters, and so on. Any verbal representations you may hear will become part of the record. I'll note that we did have a site visit on Monday with, I was there, as well as Pat, Dave, and Steve Brewhall, who is not with us this evening. Another member of the board was there as well as a couple of butters and attorney representing the appellant, I guess. Is that correct?
The appellee, not the appellant. I represent the landowner.
You represent the Welches, okay.
Correct.
Okay.
I do not represent the third party filing the appeal.
Okay, that's all right, I misunderstood. I'll run through the materials that we've received. We have an application for an administrative appeal dated 10/21. We have a building permit that was issued on 9/3. We have several pieces of correspondence between the abutters, the applicants, and Codes Office. We have a copy of the plans for the proposed construction. We have we have a letter from Mr. Davis authorizing him to represent the Welches. Another piece of late arriving email between abutters and the Codes Office. And we also have, and it's available, I think there should be copies up there, of some legal advice that we've just received in the last day or two from the MMA, from our legal representation at the MMA. I think the first thing we need to deal with is going to be the timeliness issue. And we've gone through this before, and in general, and I apologize, this is coming up last minute. At the site visit last Monday, I fully expected to see a posting on property, the permit posting, And I realized after we left that I hadn't seen it. And I turned around and went back and looked for it and did not find it. I think this, this would have been an easy, I guess I fully expected to come in here and turn this down on the basis of timeliness this evening. And that's the reason for this late coming, this late legal advice and so on. We have, I recall once in the past waiving the 40-day requirement, and it was in a case exactly like this. And the reason we waived it was because the property was not posted as it's required by the ordinance and stated on the property card. The legal advice, to summarize what we've got, and as I understand it, is that since there's no other mechanism in this town for notifying abutters of a building permit, we rely on that posting. That's not, I guess, as the attorney's letter said, that's not entirely determinative. There are other things we should consider, including whether the abutters or the appellants should have known or might have known, or how they knew and when they knew what was going on there. I mean, there's no excuse, for instance, if they saw it 3 months in advance and just did nothing. So, a couple things, I guess. The way I'm feeling is, I'm not sure how far we can go this evening. I personally would like to have the town's attorney here before we make any final decisions, but I guess I'm open. On the other hand, if we were to determine that we're just not gonna hear it, I don't think we need the legal advice. I think we have the discretion. That's my opinion. I think we have the discretion to do that. I think I'd like a little bit more advice before we opened it up, extended the period, and allowed this appeal to be heard.
I would agree with that, just based on my somewhat superficial reading of the precedent that the MMA shared with us, the Rangeley precedent, which was egregious, right? So the examples cited as a reason to extend effectively extend the deadline were pretty blatant, right? In that case, Rangeley had in error allowed a structure to be built in violation of their own codes. This is more subtle
Exactly.
than that.
Yeah.
So
Yeah.
that's a long way of saying I agree with you.
Pat, how are you feeling?
When I was at the site visit, there was something posted.
There
Was
were-
that the blasting
That was the
permit?
blasting. The blasting was posted. When I went back and I looked at all the trees that had the blasting postings on them, and there was no permit.
Because we did have an instance like this, and it was pretty blatant lack of following the ordinance, that there's no way somebody can tell exactly what's going on unless there's a building permit
Right.
posted. And even if you can't read it, you can go to the town and say, what's going on at 23 Tote Road?
Right. Yeah, I guess my feeling on it is the town is fairly relaxed on that sort of thing, and it relies on folks following the ordinance. The person who's doing the construction.
Right, exactly.
When does the posting have to occur?
It says on the permit itself, I think it says 2 days.
Prior to?
Well, it may not, it's either in the ordinance
After
or on the
issuance?
card after it's issued, and it says it has to
Okay.
be on the primary frontage.
Okay.
Of the
And how about,
Right.
how about the groundwater permit? Is this a property that's subject to groundwater permitting and that would have to be posted as well?
The septic,
No,
I think
the
there's a separate-
drainage.
A drainage. or
oh,
certain
well, and
coverage levels.
that's another question that I have, and that's kind of feeds into the legal advice we got. I think the words that they used were, it was that the lack of notice is key but not determinative. There need to be additional issues, and that's the one that I see is the lack of a drainage plan, and I think some of that stems from the fact that, in my opinion, the application was lacking. I think there's some confusing figures and outright incorrect and misleading figures in the application that may have led the codes office to overlook some of the standards.
What specifically, is it the square?
Mr. Chair, may I object to the procedural posture of which this hearing is proceeding for the record?
Go ahead, sure.
So the first question is, at a public hearing, we would typically expect to hear the applicant, the person filing the appeal, present their case to the board as a preliminary matter about what constitutes good cause. So I respectfully suggest to the board and to Mr. Chair that inquiry should be made as if the applicant, the person filing the appeal, is present either personally, by an attorney, or with someone who's been appointed their authorized agent in writing. Because the fundamental question, I think the board is probably on the right track here with looking at the good cause issue first. If the board would take a moment to look at the letter that was filed by the applicant, dated October 20, 2024, that letter expressly states that we filed our appeal in fewer than 30 days from learning of the permit. So the authority that the MMA has provided seems like good authority, and I agree with the authority that the MMA has provided. A question of notice and what kept the applicant from appealing within the applicable period. The applicant tells us in writing that they knew about the matter prior to the expiration of the appeal period. There's no suggestion that I'm aware of that they requested an extension, an enlargement, or filed a bare bones appeal and then supplemented it because maybe they had to rush in the day before the appeal period expires. Here they say they knew 30 days before the appeal period expired. So I think it's the burden on the applicant to come forward as a threshold matter and to establish good cause. It's not for the board to find it for them, respectfully. It's for the applicant to say, I missed the deadline because. And we balance that against their own statement that they knew about it. 30 days.
Well,
Thank you, sir.
I think I agree with you for the most part. I think they did say less than 30 days, and I do. I would like to hear from the applicant, so, I mean, if we're ready to do that.
Yeah.
Well, I'm not the applicant, but I think I can at least give you a timeline. I'm Dee Dee Samay Miller, and, what, okay,
Again,
I-
if she's not an attorney and she's not the applicant and she doesn't have written authority to stand in here on the applicant's behalf, we object.
We were appointed agents.
yes, but I don't know if she sent anything to the town.
I haven't got anything in writing, he's correct. But on the other hand, I'm willing to hear,
Well, I'm just curious if you
I'm willing
have-
to hear what your impression of the timeline is.
Okay, because I was the timeline. And I don't know if, I sent Margaret an email on November 13th. I don't know if that's part of your package. Just to explain what happened and how we discovered what was going on.
So it was November 13th.
Well, it was November 13th that I sent an email to Margaret because Denise had told me if I sent emails that it would get in your file. And I thought it would be important to have it in your file, the background of how we found out what was going on. Let's see, let's see.
I think more important is not when you knew, is when did the casters,
Well, I was the one who informed her.
okay, and when would that have been?
Let's see. Can I at least tell you what I went through discovering this? Since
No,
you don't-
No, I'd like to know when you told them.
Let's see, received the following day. Well, I never received the building permit or the plans until it was October 1st, because when I went to the town office, and that was on, when was that? This all started, let's see, I have to go through this. On September 30th, the area where the vernal pool was and the drainage was clear cut. So that was September 20th. On September 24th, I called the Codes Enforcement Office and said, you know, because it's in violation of our local covenants, which I understand that that's not anything that you get involved with, I understand that. But I didn't know that at the time when I called, and then, let's see, I called back. Let's see, the 24th, I think, was a Tuesday. I called back that following Friday, and I spoke with Tim, and he said that, he told me that the town doesn't enforce those types of covenants. Then he also said that he had no idea why that area was clear-cut, and that's when I was told that a building permit had been issued. So then I went to the town office Monday afternoon at September 30th to photograph the R3913 folder. And the only thing I found in the file were things that had to do with Alessandro, who was the prior owner. And after I photographed everything, I went to Denise and I asked her if it was just, they were just assuming whatever plan Alessandro had, because there was nothing on Jerry Welsh in the folder. And she said it was there, and then she went back and she looked, and it wasn't there. And they couldn't find the building permit, and they couldn't find the plans. She emailed them to me later that afternoon, which I didn't receive until I was at my place of work the next day. So that's when I received it, which was October 1st.
October 1st is when you received the
The building permit.
building permit.
Yes. And, let's see, you know, and through that whole time, you know, I had called the town office twice. I spent 40 minutes in the office photocopying folders, and nobody once told me that there was a limit or, you know, that you could file an appeal. I found that out after the fact when I spoke to a consultant that I use in my other business. He said usually the town has a way that you can file an appeal. He said, but what usually happens is nobody knows about it, and it's too late, and so it's, you know, you can't file the appeal because you don't know about it. And I
So,
would have to,
Can you give me an idea when you informed the cast?
it would have been, I would have, when I received that, it was probably October 1st or 2nd, right in there. I would have to have I don't have the
Okay.
email that I sent her.
Okay.
But I would have forwarded this then.
All right,
So
thanks.
if that helps.
Mr. Chair, may I respond briefly?
Sure.
Thank you, sir. And again, board members, I appreciate your time and the effort you're making to wrestle through this and decide this. Simply what we've heard so far is that the person who purports to be acting on behalf of the appellant knew of the permit on, or received a copy of the permit on October 1st, well within the appeal period. That the appellant themselves found out from their neighbor, either on October 1st or on October 2nd, again. So we're not even at the 30-day threshold. So there's an additional, under any calculation from what we've heard and from what the applicant wrote in their letter, there's at least 10 days to come forward and to, again, file an appeal and take action. So it's not like the cases that you read about in the MMA stuff, where those cases talk about people didn't learn about what happened until after the appeal period expired. Here we're talking about folks who learned of the permit prior to the expiration of the appeal period and missed the deadline. There's no proffer for a reason why between October 1st or October 2nd and the expiration of the 40-day period, the appeal wasn't filed. That's the threshold good cause. I have a good excuse. Something happened. I go back to the old Blues Brothers movie. There was a hurricane. There was a tornado. The car broke down. I ran out of gas. I was sick. I knew about it and missed it because this good reason. That's what the board has to determine, is we clearly know now that they knew of the permit prior to the expiration. That's a fact I submit to the board. The other fact is that they didn't file in a timely manner. That seems like a self-evident fact. And so the question is, why not? That's the good cause analysis. Why not? Thank you.
Can I go back up there?
Sure.
The reason we didn't do it in a timely manner is because we didn't know. Any of the time I was in the office, they knew that I was in the town office, I was photocopying the file, they knew that people were upset, we had conversations back and forth, and nobody ever told us, you can file an appeal. We found that by accident after the fact.
Just
May-
briefly, sir.
Oh, Pat, did you have something?
Maybe it's a good time to hear from the codes office.
If you like, if you got a question for him,
Yeah.
Tim or Margaret?
Hi, Margaret McIntyre from the Codes Office. I just want to say that I did inform them of their right to appeal on October 16th via an email that you guys have on file.
Did you have a question, Pat?
I just wanted to, and down if you want Mr. Davis to speak, that's fine.
Simply, sir, and board members, I appreciate it. Your ordinance is a public record. It's on the website. That's where I found it. And there's the old expression, ignorance of the law is no excuse. This is not a secret law. This is not something that's hidden. It's a couple of mouse clicks, and it's there.
Yep.
Thank you.
What are we thinking?
Well, frankly, I'm thinking there was plenty of time to file an appeal.
The only thing that gives me pause, Dave, I mean, what are your,
What was the date that the permit was actually issued?
September 3rd? Yeah,
September 3rd, so
Yeah.
it should have been, the permit should have been posted on the property on the 5th.
right.
Okay, and notwithstanding the council's comments, it wasn't until the 16th
That it was
that
filed.
that they discovered that it could be appealed.
Right.
I think, for me, the more important fact is not, at this point, is not when it was posted, but when it appears that the first notice that the abutters had of this permit was that something was going on,
Right.
not the posting.
No, I got it. I just wanted to make
Yeah.
sure that I think that's a secondary issue, but I
Yeah.
just wanted to make sure I had the timeline straight there. Yeah, I suppose you could, I'm not saying this is by any means determinative, but there was certainly a potential delay in this discovery process. Having said that, they knew on the first, right? They knew on the first or the second per visit to town hall, it was
Something going on they
the
didn't
origin
like,
of
yeah.
which was the clear cutting at the
Yep.
front of the property. So I guess the posting itself doesn't really, it doesn't bother me because there was, the knowledge was acquired on the first.
Right, I agree. I mean, if they hadn't found out until 3 weeks later, then
Right, then you
yeah.
might think about
Right.
it slightly differently.
The thing that gives me pause is, let's see if I can find the quote. Two things. One is that some of these delays were extensive, that the court allowed, months. And the justification for that was that, and this is the words the court used, it would be a flagrant miscarriage of justice not to hear it.
Was that the Rangeley case? I think it was, if I remember.
Yes.
Yeah.
And I think that,
And was
and I
truly
think that,
flagrant, right?
Yes,
That was
it was very flagrant, yes. And that brings up the issue of this wasn't as flagrant, and more subtle.
Do we know why the delay, I think it's probably not appropriate to call it a delay. Why it took was there any notion that the inquiry should have, the response to the inquiry more immediately should have been that there was an opportunity to appeal?
I don't understand.
Yeah, that's my concern.
It was 15 days. She went down came down here to the town office, found out a permit was being issued, forgetting about the ignorance of the law point. And then 15 days later, she finds out from Margaret that they could appeal.
And some of it, my impression
weeks.
is, and I don't know how far we should go on speculating.
No, probably not much
Folks not
further.
even here, but some of my impression is that some of it was that she was, the appellant was hoping that they could straighten this out just by speaking to codes. That they were, there's a bunch of correspondence here that sort of leads me to think that they were bringing up this point, what about this, what about this, what about this? Is this a legitimate avenue
Yeah.
of concern?
What's your perspective?
At this point, I could go either way. I could reject this on the basis of timeliness, or we could continue it. And, I'm reluctant to drag this out, because I know there's a lot at stake. This is a big project. I'm reluctant to delay it too much. But on the other hand, I would kind of like to hear from the appellant and the town's attorney in person.
How quickly can that be done?
I don't know. I don't know.
The other thing that interested me was there was something going on. The neighbors were reporting something going on. The neighbor that has filed the complaint is an attorney.
Right.
if there's one person in the world who knows
Want to know better.
what the meaning of timely is,
Yep, yep, I know.
I mean, I hate to say it for only a few days, but
But a few days can be forever. Yep, yep, I agree.
But to me, I don't understand why an attorney did not understand that they needed to
Yep.
do something quickly.
I am concerned about the building permit application and the lack of
And
oversight.
that's, yes, that's another,
You know, the fact that the coverage numbers are all over the place, they make no sense. And that bears directly on the sort of runoff control that you're required to the plan. There's supposed to be a runoff control plan, there is none, as far as I know. Is that, am I correct in that, Tim? Was there a runoff plan?
Did there
Filed?
need,
Are you talking about an erosion control plan?
No,
Are you talking about stormwater plan? That's still,
stormwater runoff.
in my opinion, that until somebody gets started and has their elevations set, I don't know, as if you, to me, that's being a landscape plan. A lot of landscape plans don't get put together until after a lot of the foundation is set, points are set, and you know where you can and can't, for sure, derive water. You know, Mary Ann, Naif, and I are trying to put together a better definition, because I feel like we need to redefine what this stormwater thing is, because it seems like it's addresses erosion control clearer than stormwater control, and what stormwater control is supposed to be doing to holding the water so it percolates. And that is a harder concept to get across, and what that is going to look like on a plan. You know, so I'd rather talk to the contractor as we go and say, okay, how are we gonna stop this water from going that direction or this direction? And,
So that is something you plan to address.
right,
As not.
And then I guess
not-
I'd also like
I
to-
guess I was concerned because it appeared to me that that was part of the standard review for a permit.
I just think it's pretty tough to put together until you know certain points.
Yeah.
You know, until you know exactly where things are at.
Okay,
And I'd like to also say, you know, all the so-called cutting was behind the 75-foot. And the other part, they didn't take any stumps, they didn't change any direction of the water flow,
I don't think we need to get into
but
that,
I just,
yeah.
okay.
it's just saying.
Mr. Chair, may I comment for just one quick second?
Yes, sure.
I hope it'll be helpful to the board. So when we take a look at your ordinance, your shoreline zoning ordinance, I think it's important to distinguish two different things when we're talking about the impermeable surface requirement. And to the extent this is a concern for the board, I'd just like to offer the board some assurances here. Because if we take a look at your ordinance, we're looking at section, let me get there, I apologize, it's gonna take me a quick minute. Section 15.10 of the shoreline zoning ordinance.
Right.
It's really important, I think, that the board bear in mind, per the ordinance's dictate, and I think this also follows up on the code's perspective, is any work in the shoreline zone requires implementation of the low-impact development best management practices set forth in the Maine Stormwater Management Design Manual published by the Maine Department of Environmental Protection. So if we're acting in the zone, we have to do it, whether or not we file a plan. The plan is required when we're kicking over 2,500 feet of impermeable surface. We have to comply with the ordinance, with section 15.10.2, regardless of whether we file a plan. So the codes office has to be satisfied that the actual work complies with the standard that's set forth in the ordinance.
The ordinance does require that you file a plan.
No, the ordinance on section 15.10.3
Right.
has the threshold. Above the threshold, you have to file a plan. Below the threshold, you still have to use the best management, the best
No, it
practices.
says, any activity involving the construction or expansion of more than 2,500 square feet of impermeable surface area must submit a stormwater management plan.
That's correct, no dispute, that's the threshold, the 20.
Right, and that's one of my
threshold.
concerns with the
But we have to, do it-
application.
we have to comply anyway with the best management practices pursuant to the
Sure.
prior statute, the prior section. So I just want to make that clarification.
Okay.
Thank you, I appreciate
Is
it.
there a note in there that says when that has to be done? Is that coincident with the?
It doesn't say, I mean, the way I got, and we're getting off, maybe
Yeah,
too
no,
far
I-
off base here, but just the way I ended up looking at this was because I was looking at the coverage numbers in the application, and they make no sense. And if the codes office was relying on those to know when to apply these thresholds, you know, those numbers are useless or misleading at best, so, in any case. I guess that makes me a little more comfortable, you know, if the codes intends to apply all these standards as the process goes along, then I think there's less argument that there's gonna be a, whatever the word was, the gross, or, you know, what was the, I can't remember the words that the court used, a bad outcome.
Right.
Yeah. You know, in that case, I think there's less argument for hearing the appeal.
Question?
Yes,
Do I have to get up there?
please. And identify yourself, please.
My name's Don Miller. I'm at 49 Tote Road. Back in '20, we developed what is now called the Tote Road Association, which runs from Gunpoint off to the end. I was duly appointed the commissioner, so I guess I stand here in that regard also. I think a further development as I follow the conversation and the points, they are the points. The reality is that since we were there Monday morning, if we're talking about how the project is developing and the checkpoints that would be made as it would go along, the entire area of the vernal pool that we all viewed Monday has been stumped, is now in the process of being filled with wood chips that were stored up behind what I would refer to as the bunker, and that has all commenced in the past 2 days. So I guess I would ask of the codes people, if we're going to have these benchmarks, and if there was no plan initially filed, where are we now? We're now left with, frankly, one hell of a mess.
I think that's probably a civil matter, because that relates to your covenants.
But we were talking about stormwater runoff and requirements for
Well,
the
again,
issuance.
I don't want to get too far, but that's outside the shoreline zone, and these don't apply.
Okay.
I think your covenants are probably more, you know, more effective in the interior than well, clearly the shoreline zoning ordinance doesn't even apply in that area. So,
Understood.
okay.
I have a question. It's my understanding that when you issue a building permit, it has to comply with Maine state law. There are some things that may not be in the local permit. I mean, I don't understand how a permit can be issued where there's a vernal pool and a wetland.
There was no issue, there was no permit issued for that. I mean, that's not anything that's before us, really, to be honest.
Well, that's what just got filled in.
But that's not
Part of,
part of this
This-
appeal, and
So you-
not part of what we have any,
So you can issue a building permit to fill in a wetland? without any geological studies?
No, I don't think there hasn't been a permit issued for that purpose. I mean, you know, whether it's legal or not is
Is a different,
a different
Separate-
matter,
it's
but
just
it's not,
separate issue.
nothing that we're considering or nothing that's before us. I mean, we have a very limited, the scope of our authority is pretty limited. And that's just outside of it. Without an appeal specifically addressing that.
So we don't have an appeal because we were 3 days late, so the law can be broken, that makes no sense to me.
What are we thinking? I mean, I'm
struggling with the appeal.
yeah,
I'm
the
tough.
timing.
Yeah, I
timeliness.
think the timing is the
We
basic
can,
issue
we
here.
can,
and-
you know, I'm, at this point, I'm comfortable with turning it down. The applicants have the opportunity to ask us for reconsideration. If they can come back to us with an argument why, you know, they could come back to us and give us a good reason why they were late and ask for us to reconsider, and we can do that.
And if there's something else that they think should be appealed,
They can amend
having
that.
just seen it,
Yeah,
they can do that.
Well,
or they
if
can
there are-
file a new appeal based on what
Yes.
they've seen,
Right.
if they're not.
Which would presumably encompass any inaccuracies in the permit that was filed,
Yeah, no.
maybe? Doesn't really, I mean, it doesn't really matter, right? It doesn't matter to us.
Not at this
Decided.
point, because this particular situation.
So how can we appeal something now since it's beyond the appeal time?
Well, what you,
I'm not,
yeah,
this is not the place to
no.
be discussing that.
Codes officer is here tonight. You might want to ask him that question. In fact, both codes officers are here tonight.
Well, I would move that we decline to hear this appeal based on the fact that the application was not filed in a timely manner.
Second?
Discussion? I think just by way of discussion, I'll just mention that I think the record discloses or indicates that the appellant was aware of the activity on the property and plenty of time to file a timely appeal and failed to do so. All in favor of the motion? Motion carries 3-0. I will note, you can forward this to the casters. They do have certain rights of appeals. They can ask us to reconsider. I believe that's within 10 days of this decision. They can ask us to reconsider, and that's not that's a fairly, I won't say tedious, it's a technical process. In order for them to get us to reconsider, they have to convince one of the members here who voted against their appeal to make a motion to reconsider, and then the board has to vote as a majority to accept that reconsideration. Typically, we don't accept them unless there's some new information or additional information or something we missed, or if you think we made a mistake. So it's not, not just because you're unhappy, there's got to be some reason for it. They also have the right to appeal to Superior Court within 45 days of the date of this decision.
That's all in this paper that was for the appeals.
There's a sheet. No, this,
No,
no, This is,
Yeah,
this,
no.
you can take a look at this if you want while you're here. That's, and the codes office, I'm sure, has copies of that. That's your rights of appeal. I think we're all set, folks. We've got some more business, and we'll prepare the notice of decision this evening as well, and that will be available in the codes office directly.
Thank you.
The minutes of our previous meeting, did you have a chance to review them?
Do I have,
They were, Margaret emailed them.
oh,
I read them, so
Yeah, I was fine with them. They looked
move to
perfect.
accept them.
okay, that's good enough for me.
I would move that we accept the minutes of our, I should have the date, right, just July 9th?
Sounds right. I don't have a hard copy in front of me.
Yeah, I've moved that we accept. Folks, we're still in session here, if you could,
Yep.
Second,
discussion,
none.
all in favor? Motion carries 3-0. Now we can take a little recess here, and I'll fill out the notice
Okay.
of decision. If you want to can you shut the tape off for a minute, Margaret?
So,